Good evening, everyone, and thank you for coming. I know we have some folks on Zoom, so I just want to get started so a lot of folks can get return to their regular evening activities. We do have a few more folks that signed up, but we'll just get started. So I'm Tara Vargas Wallace from Amplify POC. For those who don't know, Amplify is a nonprofit organization. We're a racial equity organization, and our mission is to eradicate the racial wealth gap and foster ownership in communities of color. So we know from our data research that white families have a median net worth of $247,500 a year, and Black families have a median net worth of $8. And so that's jarring to us, right? Like that's unreal. That's wild. And it's due to years and years and years of harmful systemic policies. Welcome, come on in. Um, Harmful systemic policies that put us, that intentionally held back communities of color and excluded us from being able to build generational wealth. So things like redlining, loan discrimination, gentrification, it's all rooted in racism and discrimination. And so, one of the things that we like to do is empower our communities with the resources and the tools that they need, that we need to be able to succeed. And sometimes that's a workshop, a business workshop, and sometimes that's a know your rights forum. Because it's important to know your rights. We often hear from folks out in the community who don't feel that they're well informed on what their rights are for themselves and their students. And it's really important that we get together and we have this information readily available so that we can best advocate for our kids, right? We're our kids' best advocates. And a lot of times, we know that some of the districts don't necessarily make it a point to have information about your rights readily available, and sometimes they take advantage of the fact that you don't know your rights. So we're very aware of this, and we think it's incredibly critical to empower our communities with the resources and the knowledge so that you can all advocate for yourselves and your children to the best of your ability. So today, we are honored to be partnering with the Justice Center of Southeast Mass. And we have a few panelists that I'd like to thank for being here and being a part of it today, sharing their experience and their wealth of knowledge with us. We've got Ashley Straker. Did I say that right? Okay, Ashley's supervising attorney in the educational unit at the Justice Center of Southeast Mass. We have Sophia Zoka, staff attorney in the education department as well at the Justice Center of Southeast Mass. And we have attorney Dean Douglas, attorney at charge, youth advocacy division for the Committee for Public Counsel Services. And I'd like to just give you guys a minute to sort of, talk a little bit about who you are, what you do, and the work that you do. And then we'll get started with the panel questions.
We can start. So, Ashley and I work at the Justice Center, which is located in Brockton. It's a subsidiary of South Coastal County's Legal Services, which is our parent organization, and has offices in Fall River, Hyannis, and New Bedford. Again, the Justice Center is up in Brockton, but we do serve all of you guys, communities on the Cape, all the way, as south as the Cape and as north as Avon and Stoughton, and then all the way out to Bridgewater, and the islands. Yeah. So we have a pretty good big service area, and we offer services in anything to do with education law. So special education rights. If students are have been suspended or expelled or are facing suspension or expulsion, if students are facing any other sort of school exclusion, so if for any other reason they're being excluded from school, we work with those kind of cases. We also work on cases for students who are experiencing bullying. as well as students that are impacted by homelessness and also English learners. Um, so we cover, and then, any other matter that's has to do with students receiving a quality education. Um, and then, and again, all of our services are free. And we're the education unit. We do the South Coastal Counties Legal Services does offer services in other areas of law, including consumer law, benefits law, family law, housing, immigration law, and anything to do with the elderly. Um, in order to contact us, you can call our intake line, which is on these flyers that are like up at that table up there. We have them in English, Spanish, Portuguese, and Haitian Creole. And our hours are for intake are Monday through Thursday, 9 a.m. to 2 p.m. So you can call within those hours, or there's also an online intake system, which you can fill out at any time. Um, yeah.
Hi, my name is Dean Douglas. As I was introduced, I am the attorney in charge for the Hyannis office of the Youth Advocacy Division, which is the juvenile office of the Committee for Public Counsel Services. It's a mouthful, but what I usually tell people is we're the public defender's office, and I am the attorney in charge of the part of the public defender's office that represent children. So while a lot of my services are primarily related to delinquency and delinquency related matters, such as whether or not your child's charged with a crime or harassment prevention orders, child requiring assistance issues, a lot of juvenile court matters. It also extends into educational law, where oftentimes a lot of my clients have education-based issues, so we represent in that aspect as well if there is a connected delinquency CRA or potential harassment prevention order. However, if you need help anyways, you can always reach out to us because we can direct you to other resources that could provide you those same services if it doesn't fall under our mandate, but don't be afraid to give us a call.
Wonderful, thank you. Okay, so I forgot to ask if anyone needs translation services. We have Portuguese, Spanish. Anyone need translation services? Nope. Okay. I'd like to recognize that we have Senator Sue Moran in the room. Hello, hello. District Attorney Rob Gallivois, thank you for joining us. Okay, so with that, let's get started. So the first questions are going to be, we have a series of topics that we're covering. We're going to be covering special education, school discipline, bullying, English learners, and students impacted by homelessness. So the first series of questions are going to be regarding special education. And I can just ask the question, whoever feels comfortable answering and adding to that, please feel free. This is a very informal event. So the first question is, what is an IEP versus a 504 plan?
So a 504 plan is for students who have a disability that impacts a major life activity. And those students who only would require accommodation. So such as, I guess the easiest example would be for a student who is in a wheelchair, for example, to be able to like take the elevator to go to like the second floor in class in order to access their education. Whereas an IEP is for students who require special education in order to make progress in school. So they would have a disability that impacts their ability to access their education. So, for example, for students with social emotional disabilities, like they may require, services in the classroom, like mental health supports in the classroom in order to help them. Or students who have dyslexia, for example, having a special education teacher who provides reading services to them.
Thank you. Next question. What is a school district's child? What is a school district's child find obligation?
Yeah, so I can answer that. So the all schools and school districts have what's called a child find obligation, which is that schools have a responsibility to affirmatively um, seek out and find and identify students who could have a disability. And it's actually their job to identify those students and suggest and propose evaluations. So while parents can at any time request evaluations for their student if they are having concerns, it's actually also the school's obligation to be watching out for those students and paying attention to signs that a student might have a disability that's impacting them that's keeping them from accessing their education. So um, some things that schools are supposed to kind of look at are, for example, if a student has obviously, grades, that's like an obvious example, I guess. If a kid is struggling in their academic classes, is not getting great grades, that might be a sign that that kid is struggling and there's something else going on. But it can also be conduct issues. So if, you have a kid who keeps getting in trouble, keeps getting suspended, the school does have a responsibility to, pay attention to these kind of things and notice, they're having this pattern of conduct issues. Maybe there is a social emotional disability. Maybe again, there's something going on that's causing the kid to have these conduct issues. So again, as parents or anybody else, honestly, who is concerned about a student, that could also be a pediatrician, um, family partners can request evaluations for an IEP for special education at any point. The school also does have that affirmative obligation to be identifying students, to be noticed, picking up on if there's a pattern or there's something going on. Even like attendance, if a student is missing school a lot, that's a sign that maybe there's something else going on there. Um, and so the school does have that obligation to identify those students and propose evaluations and let parents know.
Sure.
So this is my question, just generally, maybe it will help someone out there. Oh, I'm really shy usually. I can't believe I'm asking this. This is just so sometimes when you see a grade trend with a student, um, the teacher or in the process of evaluation, they say, "Oh, well, you need to see your pediatrician because I think it might be ADHD, and we don't deal with that at the school." I see that a lot talking to parents, so I don't know if you have any advice around that for parents or what to do.
Yeah, so actually, a student does not need to have any sort of medical diagnosis in order to qualify for an IEP. So I I have yeah, I have heard of, schools suggesting that, but actually a student does not need to have an official, from medical doctor ADHD diagnosis. If the school does an evaluation and they determine that they think, attention issues or executive functioning issues are what's keeping the student from being able to access their education, then the school can still create an IEP based on that. A student doesn't actually have to have anything from their doctor saying they have ADHD, dyslexia, autism, anything. They don't have to have a medical diagnosis of anything. If there are, symptoms of ADHD, for example, that are impacting a student, um, the school can still create an IEP.
That's a great question because we hear that a lot from providers that schools will tell student or tell their parents that they need to go elsewhere to be evaluated. And if a student has a disability, regardless of what type of disability, the school has to deal with it if it's affecting the student in school. And if a school is telling a parent that, they're basically punting their child find obligation to someone else. And so what I would suggest for parents dealing with that situation is to put in writing, and I would always recommend an email because then you automatically get a saved copy for yourself, an email requesting for your child to be evaluated and explaining why, like especially like if you're seeing behaviors, because what we see is that students are typically evaluated in terms of their cognitive abilities and their academic achievement. And so they may be able to do as well as their peers, but there might be something that's preventing them from, doing as well. For example, maybe because they keep getting suspended, they're not in school, so their grades are low, and that's why they can't access their education. Or maybe it's an attention issue, and that's why they're not accessing their education. But either way, again, like it's the school's child's find obligation to locate and identify and propose evaluations for students who they suspect of having a disability. Yeah, so great point. So once a parent requests an evaluation, or any caretaker or provider requests an evaluation for a student, again, it doesn't have to be in writing, but we would always suggest or recommend something in writing, because otherwise people can say like, oh, I don't remember, or no, it didn't happen. 5 school days afterwards, the district needs to provide the family with an evaluation consent form listing out the evaluations, and parents can agree to it. They can reject it. They can request additional evaluations. They can reject certain evaluations. They can say, for example, no, I don't want a home assessment, but I do want a psychological assessment.
Thank you. So keep receipts. That's the lesson here. Okay, thank you. If a parent sends a request to a school district asking for their child to be evaluated for an IEP, what are the next steps that the school district must take?
Well, apart from the sending the releases at home, they have 45 days to actually start and implement the actual evaluation and to complete it and to have the IEP meeting at the school. So once they receive that written, excuse me, the written request, the clock starts ticking, and then they have that 45 day to have the assessment done and then actually have the IEP. So it's important for them to get get the ball rolling. Is that?
I believe it needs to be proposed within the 45 days.
Yes.
Copies need to be, so districts that have a meeting, the IEP meeting at 45 days, then they take 2 weeks, they're out of compliance. So the IEP needs to be in the parent's hand, proposed within the 45 days, I believe.
Yeah,
Not
so
just the meeting.
yeah, so actually, to your point, yeah, so like also, 5 days after they need to give the consent, parent has, can sign that consent form, and then it's actually once the parent has signed that consent form, then then they have 30 days to complete the evaluation part, and then the 45 days, school days, sorry, to actually have that IEP meeting. And yes, you're right. They are supposed to give a proposed IEP within 45 school days. Sometimes schools, they do have the option of asking parent to waive that and allow the 2 weeks. But technically, they are supposed to have, if they are going to take an extra 2 weeks after the meeting and it goes beyond the 45 days, they are supposed to have parents sign off that they're waiving that right to have the proposed evaluation in 45 days. But you are right, sometimes schools don't always get that consent and still send it out 2 weeks later.
I love this. We're all learning together.
It's very specific.
Could you explain the process of placement and how it relates to least to most restrictive environment? Give examples of how students can be placed in a sub-separate setting versus with their peers. Do you want me to repeat it?
Yes,
No?
please.
Yeah, yes. Could you explain the process of placement and how it relates to least most restrictive environment? Give examples of how students can be placed in a sub-separate setting versus with their peers.
So if a student is put on an IEP and parent accepts, there's a placement consent form. And so the different options for a placement consent form is there's full inclusion. So that would mean that the student would receive special education services, but they would be in a classroom with their non-disabled peers for most of their school day. Then there's partial inclusion, and that means that the student can be either pulled out for, so say for example, if they get speech and language services, so they would be pulled out of their general education classroom for the speech and language services, or they might be put in a smaller classroom for other classes such as math or ELA, like maybe they need a smaller environment where they would be with other peers who are also on an IEP that have a similar disability and similar needs as them. And then there's a substantially separate program. So that is where a student spends at least 60% of their day in a smaller classroom with peers who are also on an IEP with similar disabilities and similar needs. Then it goes to a more restrictive environment, and that would be the therapeutic day program. So that would be a school that is for students with who are only on IEPs, similar disabilities, similar needs. And then you go higher than that, and that's the most restrictive would be a residential program. And so that would be for a student who needs supports 24/7 throughout the year. So students who need like supports with like daily living skills, or maybe their disability affects them like not only during the school day but outside of the school day. And so there are very few students who should be placed in a residential school. Even a therapeutic day school, there shouldn't be that many students in a therapeutic day school. So students have the right to be in the least restrictive environment as much as possible. So basically, the law requires for students to be with their non-disabled peers as much as they possibly can. And the reason why this is very important is because way back when they used to take, students with disabilities, any type of disabilities, and basically, keep them all together regardless of their needs. And so they weren't really receiving an education. And so it was extremely discriminatory.
Absolutely. Thank you. And that's a perfect example of the difference between equity and equality, right? Like in order to get to equality, we got to be equitable first. And that means sometimes we got to treat each individual differently in order for everyone to be treated equally, right? Because we have to address certain issues that individuals have in order for them to be more successful in the larger population, right? So thank you. That's very helpful. And sure.
What is the best way to document if the school is not being given certain accommodations expressed in an IEP?
The best way is in writing. Um, Send emails, save emails. If you have a phone call, follow up the phone call with an email to the person you had that phone call with, recounting the substance of your conversation so that if there's later some discrepancy in terms of what was said, what was communicated, if it's in writing, people tends not to have miscommunication. They'll be clearer in their communication. Sometimes when people are speaking to you over the phone, they use vague language to sort of not be committal. When you put it in writing, they know that it's being saved, so they say what they need to say and they're correct in what they're saying. And that's the best way to do it.
Welcome.
Also, like if a student is supposed to be receiving certain things on their IEP, such as like related services. So I'm going to give the speech and language service as an example again. So the school is actually supposed to be keeping a log of when they're meeting with the student, and when the student and the that person who's providing the service they're not meeting. So that's important as well for like compensatory services. So if a student is supposed to be getting a certain service, a certain amount of time during the week, and they have not, the school eventually needs to make up that time for that student. And so parents can request to have that log of the related service provided to them.
Questions?
Would those only be in secret?
For the related services, well, sometimes related services are in the B grid, like they can be pushed into the classroom. I think it's harder for, like, say for example, for a student who's receiving math services, they may not be logging in like how much time they're spending with the student, but so that actually might be harder to prove. But you can ask for the school to like create some sort of like communication log about the type of support that's being provided to the student, like on a daily basis or on a weekly basis, for example. That might be a way to get the information that parent is seeking. So I've seen it more with related services when the student is actually pulled out for like speech and language services, occupational therapy, physical therapy. They do have to keep logs of when they're meeting with the students. And so parents can request that.
I want to go back for a minute to the different placements. What happens if a family doesn't agree with the suggested placement that the school is saying a child needs?
Yeah, I can answer that. So a parent has to sign off before a student can be, their placement can be changed. So a school cannot just say, well, we think they should be in a therapeutic day, we're sending them there. The parent has to sign off on that placement form. And let's say that a student was in a sub-separate program. The school district is now proposing a therapeutic day placement, which is more restrictive. Parent does not want that, thinks their student is good in the sub-separate, wants them to stay there. The parent can reject the placement, and the sub-separate program is called the stay put placement. So wherever the last agreed upon placement, the last placement that parents signed off on, that's their stay put. And so during the course of, whatever the dispute of parent, doesn't want the student to go into a therapeutic day school, the school district does, the student has the right to remain in their stay put placement and keep attending. So like in the example I gave, they can keep attending their school in that sub-separate program until the dispute is resolved. But ultimately, I mean, parent does have to sign off to change placement. Except in like there's a very special circumstance where they wouldn't, but for the most part, yeah, parents have to sign off on any change of placement.
So there is something that the school district can do, and that's they can file a complaint with the Bureau of Special Education Appeals, sorry, to have the student moved to the therapeutic day, for example. That's pretty rare. We see those situations when a student is either a danger to themselves or a danger to their community. So we only see that in very serious cases.
So my kids are in their 20s now, but I actually had a situation with my oldest daughter with special needs, and I rejected the placement and fought the district and won to get her into where I felt was more appropriate for her. And that was years ago, and it was a very complicated process. And I felt very alone, and I had no idea what I was doing. And that's why these informative sessions are so important. And I'd like to thank, before we move on, so does anyone have any more questions on special education before we move on to the next subject? Yeah.
Translators tonight, but as a social worker, I can't, resist to pop up the question. So, a very quick question regarding IEP. How about when the IEP is already placed? Let's gonna take an example: a child, a 5, 6 years old child with some speech concerns, and the child is already receiving some speech, service from other, I don't know, spouting or something else. At some point, this IEP can be enriched with these professional from this other area. Is the parent has the right to request to the IEP team to call to these other, service providers and join this IEP meeting to improve the IEP plan eventually?
Yeah, so parents actually can bring pretty much whoever they want to an IEP meeting. So if the parent has outside providers, yes, bring them along. Yeah, parents are invited to bring any outside providers, and often that's very helpful, especially if there is a disagreement, because sometimes maybe the school won't listen to the parent, but maybe we'll be more likely to listen to a professional who is saying, no, I think this is what they need as well.
I just want to add to that because the IEP process can be very intimidating. I've had parents like bring friends along, bring a neighbor along, someone just to take notes. So if you just want to have someone there to support you, it's parents' legal right to have that.
That's really good to know. And also, the Family Resource Center has a school liaison who is educated on education IEP stuff. So definitely reach out to them. They're a great, I used to work for them. They're a great organization. And okay, yes. More questions on Zoom.
Um, so, so for you guys who don't know, on the Cape, we have a Barnstable Human Rights Advisory Commission, and this is referring to that. If a parent contacts the intake team of that Barnstable Human Rights Advisory Commission, could their intake team contact the Justice Center, or does the parent have to contact you guys directly? I think that would be if maybe the parent felt more comfortable, going through maybe people that they knew at the advisory commission.
So we would ultimately eventually need to speak to the parent, but they can call with the parent can call with like their provider. They can, as long as the parent gives consent for us to be talking to them, they can call with them so that they don't have to do that phone call alone. I mean, eventually as part of the intake, we will have to we would have to speak to the parent, but they can certainly call, with a provider, and yeah.
Okay, one more question. If a student is diagnosed with a SLD in reading, writing, or math, is it correct that the school does not have to accept the diagnosis and the child can be placed on an IEP under another category, emotional or neurological, for example? If the IEP is accepted by the parent under the other category and then does not progress, can the categories and goals be revisited later without more testing? What are the implications of accepting an IEP if you do not agree?
So I don't think parents should be too hung up on what the student is found eligible under. So regardless if they're found eligible under a specific learning disability in English, math, or writing, or a social emotional disability, it's really about the types of services that they're getting. So if they're getting the services that they need in order to make academic progress, that's more important because you could have two students who have a specific learning disability in English, for example, or in reading, and they could need completely different services, even though they, are found eligible under the same category. So focusing on that specific, the specific services that that student needs is more important. Now, if the student is not making academic progress under the IEP, what may need to be done is an extended evaluation. And so the school can agree with parent that they don't have enough information to provide a full IEP, like a completed IEP for that student. And so more evaluations can be done. If the school would not agree, then parents can request an independent educational evaluation. And depending on the family's income, the school may have to pay for it in full. The only catch to that is that it would have to be an evaluator that takes the state rate, which is pretty low. They did increase it recently, but the school should also provide recommended evaluators in the area that do provide independent educational evaluations.
I also, it's important to know that sometimes a child can have more than one disability. So if there's a disability that's identified as the primary disability, you can also make sure that they have services to address any secondary disability that that child might have. So for example, you might have a child with ADHD. That's identified as the primary disability, but a specific learning disability in math or English or something else could be a secondary disability for which services can be provided. Also, if you think your child is not making sufficient progress on the curriculum, the simple question is to talk to the teachers and see who actually knows what's in the IEP. You'd be surprised how many teachers actually don't know what's in an IEP, and therefore the child might not actually be receiving the appropriate services for the child, so there's no adequate progress. So part of that is just having the relationship and having the conversations with the service providers and with the teachers to make sure that your child is actually being taught the way he's supposed to be taught. I would also advise parents to make sure that your child know what's in their IEP and the services that they should be receiving so that they can also report if they're getting those services, because that's the other part of the equation is if you have an IEP but the services are not being provided or the teacher don't know what the IEP actually entails, the child will not make the progress that we want them to make. So having those conversations and being present in those moments can save you a lot of headache.
Parents also should be receiving quarterly IEP progress reports, and that actually goes over the progress report should include each of the goals, it goes through each of the benchmarks and should be explain like how the student is progressing, whether they are meeting the goal, whether they're not meeting the goal. So parents should be getting quarterly progress reports that let them know. And if a student, if a student is not making progress, isn't meeting those benchmarks, it should be pretty clear in the progress report that the student is not meeting this benchmark. And then things might need to be adjusted.
Also, if a parent does not agree with the category that the student is found under or the types of services that the student is getting, they could also either reject the IEP in whole, which we don't really recommend that, because if there's even one thing you agree with on the IEP, then parents should partially reject. And so with partial rejections, anything that you write is rejected in the IEP. So for example, you could write that you don't agree that the school isn't providing a certain service, or the school is not providing enough of a certain service. You can also write, that you don't agree with the category the student is found under. So those are like examples of like the partial rejections, and anything that you don't partially reject, everything else will be accepted. And as soon as parents submit the IEP, all of those services, supports, accommodations will be provided immediately, or should be provided immediately.
Thank you, guys. Great answers. There's one more question on Zoom. If there is need for advocacy in an IEP meeting for a family, is there free help on the Cape for parents when they don't have resources to pay for an advocate?
The Justice Center of Southeast Massachusetts has an
Okay.
education unit.
Link is in the
And
chat.
if you are 200% below the federal poverty guidelines, then we would be able to provide services depending on the type of matter it is. It could be a situation where we could provide full legal representation, or maybe you just need advice on a case. And so, we are available even though we're in Brockton. We cover the entire region.
Nice, 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 nice. Yes.
I have one more question. So once the child is placed on an IEP, the IEP is updated once a year, is my understanding, right? And there's a meeting once a year. When you have that like how long can they at that meeting? I know there's like 3 years where it's good for, and then but a yearly meeting, could they take your child off an IEP? Or I guess trying to understand the yearly meeting and
Yeah.
what to expect.
So students if they are eligible for an IEP, they have to be reevaluated every 3 years. So the school has to conduct new evaluations every 3 years. There has to be a meeting, a minimum of every year. Parents are welcome to request an IEP meeting whenever, yeah. They don't have to wait for the 1 year, but schools are required to provide an IEP meeting at least once a year. And that's to go over it should be going over the whole IEP, looking at did the student meet the goals that we had for the IEP this year? Are they not? Or should we change the goals? It's really to look at the progress over the course of the year and whether the IEP was successful in helping the student make progress or whether changes need to be made. Ideally, an IEP should be updated every year because if they're making progress, the goals should be changing to become, more advanced. But yeah, so that meeting is to just look at, are they making progress under the IEP? Did they meet their goals? If so, let's create new goals. Did they not meet their goals? Why not? What other supports need to be added? Yeah.
Eligibility can't be revisited.
So it can be, sorry. So eligibility does get revisited every year. Again, if a student every year they do go over eligibility, and if the parent disagrees, so let's say your student's on an IEP, the next year the school says we don't find them eligible anymore, um, and propose that, you can again reject that, and then the student has the right to stay put. They have the right to continue to have those IEP services from the last agreed upon IEP until the dispute is resolved. But
I would say that if a school is going to take a student off an IEP, that they should reevaluate the student, even if they haven't met the 3-year mark. And if they have evaluations and the evaluations say that the student no longer requires special education services, parents can request an independent educational evaluation.
usually, I mean, I would say a lot. Yeah, a lot of times the like eligibility part of it, if it's clear they're still eligible, it's kind of like we go through eligibility, but yes, they're still eligible. But if they are trying to take a student off of it, again, they can't. That's a change in placement technically, so they can't make that change unless you sign off on
And
it.
you,
Yeah.
yeah. Well, even if they were to, you would have 30 days to, submit your response. Even for a newly developed IEP, you don't have to sign it on the spot. You actually have 30 days to consider it.
I'm going to ask that in the interest of time, we've got 4 or 5 other topics. So I'm going to ask that we move on, but please reach out if you need further assistance, okay? Okay, so moving on to school discipline. Yeah. What due process must every student receive before being suspended? This is an issue that happens all the time. And it's their due process we're finding is being violated. So we really need to be sure that we know what due process is the school district must take.
First of all, for any suspension or expulsion meeting, they need to receive notice in writing of the charges, um, for which they're being considered for discipline. It needs to come home in the language of the home. That's another thing we run into where it's it's a Brazilian family and they're getting all their communications in English. So it comes home in the language of the home with the charges of why this person is being charged with, being given an opportunity to be heard, being notified of their rights that they get to get representation if they choose to bring it with them, and when the hearing date is, and the fact that they also get the right to have a translator at the hearing. Oftentimes, that's another thing we run into. They have the right to a certified translator at these hearings.
So
Before before the suspension, yeah. So it's think of it like if they're gonna instead of calling you up and saying, "Hey, Mr. Smith, you need to come in tomorrow for a meeting about your son. We're thinking about suspending him." There should be a letter sent home to you saying, "Dear Mr. Smith, we would like to have a suspension meeting for your child. Your child is accused of X, Y, and Z. You have the right to for representation at your own cost and tell you when the hearing date is going to be." So, at least bare minimum. There's some other stuff that could be in there, but that's the bare minimum. Sometimes I've represented people where the kid's told to don't show up unless you bring your parents, right? And then parents are walking into meetings, they don't even know what's happening. So that's not a justifiable suspension meeting. That's a due process violation.
Yeah, there are a lot of like nuances of what exactly you get depending on how long their school is considering suspending your student, whether they're considering suspending or expulsion. There are like 3 main statutes that discipline is under, so it also the rights depend on which statute the school is proceeding under. So there are some differences about what you get depending on what the student is facing. The kind of bottom line rule is the greater the potential punishment, the more rights. So, if a student is facing an expulsion, they're going to have more rights than if they're facing a 1-day suspension. But at a minimum, students should always be getting a written notice that informs them and an opportunity to be heard and to dispute the charges or explain mitigating circumstances.
I also wanted to add that one thing to note, just as Sophia said, the more exclusion that a student is facing, the more rights they have. But that also includes cumulative days that a student is out. So say, for example, so the magic number is 10. So if you go over 10 days in a school year, that is considered a long-term suspension. So if you have been suspended, for example, for 5 days in September, but then you're looking at a 6-day suspension in January, that would be 11 days. And so you would have long-term suspension hearing rights, including the right to an attorney, the right to review all of your student record, as well as, sorry, as well as the right to have the hearing recorded.
Thank you. What is Chapter 222 and what does it require schools to do before a suspension?
I brought them because I think this is a big issue that has been in Brockton at least. I don't know if it's been as big of an issue down here, but Chapter 222 has been around for how many years? A long time. Over a decade. Yeah, over a decade. Basically what it says is that schools have to consider alternatives to suspension before suspending a student. It does not mean that they can't suspend a student, but before they do that, they have to consider alternatives and they have to actually document those, what they've tried. So before a student, let's say that a student gets in a fight, they're facing a potential suspension, the school has to document that they have anything they've tried before suspension. So, if they've tried to have a peer mediation with these kids because they've been having issues for a while, or they had to write a letter of apology, or even they've been in school suspended. The school has to document that they have tried alternatives to suspension, alternative forms of dispute resolution, or they have to document why that would not be appropriate. So for example, like if a student, does something that's like a very serious physical assault, maybe the school feels that, peer mediation would not be appropriate in this circumstance because whatever, the student does the other student doesn't want to face them or something. There's some reason. The school has to actually document why it would not be appropriate to use alternatives, and why they believe that the suspension has to happen. So again, students can still be suspended even with this Chapter 222, but it just requires that schools actually document their attempts to resolve the situation using alternative solutions before they actually suspend a student and keep them out of school.
So I just wanted to add, because Sophia just reminded me of in-school suspensions and the rights around that. So there aren't that many rights around in-school suspensions. Principals can just like have a conversation with the student and say, I'm going to in-school suspend you. Again, the magic number is 10. If a student is in school suspended for more than 10 days, that is a long-term suspension. And therefore, if they're even considering another in-school suspension, they have a right to an attorney, right to have the hearing recorded, etc.
Thank you. We're good?
There's a question.
Oh, there's a few. Okay.
Ashley, when you say a right to an attorney, does that mean a free attorney or does that mean at your own cost?
At your own expense.
Anyone else? Go ahead.
In-school suspension, is that considered an alternative?
It is considered an alternative. However, if a student is in school suspended for more than 10 days, that is a long-term suspension.
I thought I saw another hand. No?
Also to the woman in the green jacket. So when a student is disciplined, it's their rights that needs to be protected, like their due process rights. So, if the student isn't working, they could possibly get a free attorney.
Interesting. Thank you. Yes. What does an in-school suspension entail?
So an in-school suspension would be a situation where a student would be not in their regular classroom. They typically would be put in another classroom. Maybe they would stay in the office, and they would be given, some work to do. So they would still be allowed in the school building. They just wouldn't be allowed to participate in their regular school activity.
And if it's for over half the day, that counts as an in-school suspension. So sometimes if a school like keeps the kid out for only like makes the kid sit in the office and do work for half the day, if that would be an in-school suspension for it would still count as 1 day of in-school suspension, even though it wasn't technically like the full day. If it goes beyond that half a day, it counts as 1 day.
And that's a great point. Thank you for bringing that up because, again, magic number is 10. So we see a lot of kids with behavioral issues getting pulled out of class a lot. So if you have a student who's continuously being pulled out of class for more than half of the school day, and it's over 10 days that they're doing this, long-term suspension, you have all of the rights that would be afforded to a student. As I said before, right to an attorney, right to have the hearing recorded, and they shouldn't be suspended. And if a student is on an IEP, which we're going to get into this later, but there are additional rights for students on IEPs or even 504 plans who are long-term suspended or who are possibly being long-term suspended.
One moment, we have more questions in the back.
What is a school required to communicate to a family regarding a child being pulled out and being put in an office for half a day? Is that something that I'm required to know about as a parent, or?
Yes, because that would be an in-school suspension. So the school would have to put in writing to you that your child has been in-school suspended and the reason why. And they would actually need to have a meeting with you either before the in-school suspension happens or afterwards, but it would have to be soon after.
There's one on Zoom. I'm not sure. It feels like more of a question for the school, but we'll see if you guys can answer. It says, how often and how many of the staff are properly trained in restraining children? It's a great question.
Most likely there shouldn't be any restraints happening in a regular school setting. Yeah, there shouldn't be any of those. Now, if somebody's having a significant mental health issue, oftentimes there are school resource officers that can potentially intervene. There's also access to the nurse or accessing 911. I don't think a regular teacher in a class should be putting their hands on any child. Period. End of story. I can't imagine a situation where that would sort of be a thing, especially to be regular enough for this to be a question.
And if there are, I just wanted to say really quickly, if a student has been restrained, a parent should be getting a report home, a written report. Anytime a student is restrained, they should be getting a report home that says, what the incident was that led up to it, how long the student was held in a restraint, and the type of restraint, I would imagine. So the parent has to get a notice every time their student is restrained. And if a student is being restrained more than once a week, like every week, the school does have a responsibility to look at that prior week and say how many restraints. Oh, this student had to be restrained multiple times. They have to have a meeting to look at, why was the student restrained so many times? What other approaches should we be taking? Does something need to be changed in their IEP? What's going wrong? Because again, yeah, ideally students wouldn't be restrained at all. Obviously, there are some very significant situations, if a student is hurting themselves or someone else. But I mean, yeah, so I've had a student who was being restrained very often, and the school does have responsibility. Again, at the end of every week, they have to review, and if they notice, oh, we have one kid who kept getting restrained, they have to convene the team to talk and figure out, okay, clearly something's not working here.
And there are certain staff that actually should be trained in restraining students, and it should also be reported to parents who it was that restrained their child and if they have been trained.
Are there any circumstances when a teacher can pat down a student? So not the administrators, not the nurse, not the SRO, teachers. Are they allowed to pat down students ever?
I guess it would kind of depend on the handbook. Like,
It, it would something like that would be covered in the handbook, but again, I can't imagine a circumstance where that would be appropriate. Not only is it not it's dangerous. I think if you have a concern, you report it to administration, and then the administration can take the appropriate steps to search the student if it's necessary. If you are a lone teacher trying to search someone that doesn't want to be searched, and if you're touching somebody that does not consent to be touched, that's a problem. So I can see this fracturing in so many different ways, but I don't see why, say, a random English teacher need to pat search a student. If there's a concern, send a kid to the administration, and then the child would be addressed there. Whether or not it needs to be brought to the attention of the school resource officer, that's different. Maybe the administration can deal with it privately and separately, but should not be doing that.
Yeah, and if it's a situation where a student is being searched, there should be more than one person in the room for that child's safety.
Yes, thank you. This is a good one. There are 4 circumstances in which a student can be expelled in Massachusetts. What are they?
so the only time 4 circumstances where a student can be expelled are if they bring a weapon to school or a school-sponsored function, they bring drugs to a school or school-sponsored function. So again, school-sponsored function means not just during the school day, it could be an after-school dance, it could be a field trip. It doesn't even have to be necessarily on school grounds. If it's a field trip with the school, that still counts. So weapons, drugs, or assault on school staff. And then the 4th is if they've been charged with felony delinquent. I mean, there's not really, I guess, felony. You guys don't differentiate, but a felony delinquency.
It's not just charged, they'd have to be found, they'd have to be convicted.
Yes.
So if you're charged with a felony, that triggers a suspension potentially. And then if you are convicted, then the school could move at their own discretion to expel the student.
And I also wanted to add, for assault on staff, it has to be either the principal, vice principal, or educational staff. So SROs do not count. The custodian does not count. The cafeteria workers do not count. It has to be educational or the vice principal or principal. And the principal may expel the student. They don't have to. They should be looking at alternatives.
The question is why that selected group? Why only those professionals get the coverage of protection?
It's out of statute as written. It's 37H. It covers basically educational staff. First of all, an SRO is not a staff member at the school. He's a police officer. Janitors technically don't tend to have interaction. So I think it covers a lot of people who have one-on-one or regular interactions with students. So I can't foresee a situation where a janitor needs to get involved with a student, but like a teacher in a classroom, an administrator, these are all covered by that statute.
It could also be classism as well.
Okay, girl, that's what
Also-
I like to hear. Speak the truth.
I also did want to just add that for that weapons and drugs are defined by statute. So it's not so one thing to note, for example, is that marijuana is included. So a student could be 18 and legally allowed to possess marijuana in the state of Massachusetts. If they bring it into school, they could be subject. They still can't bring it into school. They're still could be subject to that.
That makes sense. Are there any state legislators in the room? We need to change that law. Yes. Good. Cafeteria folks need protection too. Other staff members need protection
But
too.
part of it is if a non-selected or non-identified staff member is assaulted by a student, chances are that assault is covered by 37H and a half, which then, most likely might be a felony. Then that you get to the same end result, but in a different direction.
Okay, thank you. Moving on to the next question, which is the last question in this topic of school discipline. What added protection do students with disabilities receive before they are suspended for longer than 10 days? Good question.
So again, the 10 days or under, students with disabilities are treated the way any other student would be treated in terms of discipline. But once we pass the magic 10 days, we reach day 11, students with either an IEP or a 504 plan have the right to what's called a manifestation determination review. And this is a review and the two questions that should be answered at this review are, was the student's conduct that they're facing discipline for related to a manifestation of their disability? And the second question is, was this a result of the IEP not being followed? And if it's yes to either of those, then the whatever discipline that the student was facing cannot be imposed because it's either a result of their disability or or a result of the IEP not being followed. So also a result of their disability and not getting the supports they need. And again, this is once we reach past the 10-day mark. Before that, they do have it's the same as any other student, but once we pass 10 days, we get that review. And if it is found that their conduct was a manifestation of their disability, they cannot have whatever punishment they were facing. And if that is the case, the school has the responsibility to conduct a functional behavioral assessment, or if they've already conducted that, to update it. And then based on that functional behavioral assessment, they should create a behavior plan, which is basically a document that identifies, some of students' main conduct challenges, main, areas where they get dysregulated or, whatever the issue is, and some of the triggers, like so for example, a student who gets really dysregulated whenever there's a transition, a behavior plan would include, this is a trigger time for this student. So some of the things that we should do for the student is warn them before a transition, or, have fewer transitions for them. And so if it is found to be a manifestation of their disability, then that behavioral assessment needs to be conducted and behavior plan needs to be created, or if it's already in place, it needs to be updated.
I just want to address, the special education piece in this because, as we've said before, it's really important that when the schools are proposing the evaluations, parents also make sure that the right types of evaluations are being done. Because what schools sometimes do is that they'll look at the academics and the cognitive skills, but they won't look at the social, emotional, issues that the student may be having. So like a functional behavioral assessment, for example, can be requested, or a psychological evaluation with what's called a BASC assessment can be done, and that looks at where the student is like in their social, emotional well-being. So those types of evaluations can be done, as well as observation. So if an observation is done and a student has a behavioral issue, I would suggest that parents can request that the student be observed in the classroom that they're having the most difficulty. So if, for example, they're always misbehaving in math, then the evaluator should be, observing them while they're in math class. And if an IEP does not include services and supports for a student's behavioral challenges, parents can partially reject the IEP and put in the partial rejection that the student requires, more services in order to address their behavioral challenges. And even for situations where, an IEP does state that a student has behavioral challenges, and, states that in the IEP, I would suggest getting specific, like what does the student do? Do they have a low frustration, level? And when they do they punch, kick, do they bite? Having that in there is really important because when you get to the manifestation determination review, sometimes you'll hear the most ridiculous reasons why a student, the disability was not part of the student's disability. We've heard a lot, and sometimes it's because it's not specifically written in the IEP, which is not what the school is supposed to be only looking at. But it helps a lot if you have like the types of behaviors that are typically seen in the IEP, as well as a behavioral intervention plan as well.
Thank you. This is so important because if you don't know that you can request these exams or these request certain things in the IEP and your child with special needs is disciplined in the same way, that's unfair. Like that's not equitable, right? Like that's not reaching equality. And so that's something that we really need to do better making sure that we get this information out to parents and caregivers so that they can best advocate for their kids or students.
Also, as it relates to an IEP, the two primary takeaways I would have people take is that an IEP is supposed to identify the disability, and the IEP is supposed to also talk about the services the school is going to provide to address that disability. I've seen IEPs that's talking about what the student's going to do, but never really covers what the school is going to do to help the student meet those goals. So goals are great, but it should delineate quite specifically what services the school is going to provide, how often it's going to be provided, days of the week it's going to be provided, sometimes who's going to provide it so that you know who's, sometimes if something is going wrong, if the student have a specific support staff, you could potentially write that in an IEP so that if this child becomes dysregulated, this is the support staff that you would look to help get the child back to being regulated. A lot of this stuff, if you put it in the IEP and you ensure that people know it, then we oftentimes won't find situations where you need to have multiple meetings and there are issues. So oftentimes, and I know it's intimidating when you're sitting in the room with 5, 6, 7, 8 teachers, and sometimes you're the only parent there. If that's the case, bring someone along with you. But you want to make sure that the IEP covers the things that need to be covered. If you're seeing behavior in your child at home, mention that in the IEP meeting so that, because sometimes that's probably at some point going to pop up at school as well. So you want to make sure that they're aware of it and it's not some new thing that the school is going to consider to be, this is a new thing that's not in the IEP. You want all of these things to be documented and listed in the IEP. Sometimes it's, even if it's just mentioned in IEP, that provides some level of protection.
I also wanted to mention sometimes students, like for example, we have some students who have been diagnosed with autism, and sometimes they're masking during the school day, and then after the school day, that's when parents are seeing the behaviors. So it's really important for parents to discuss that with the school. And just so you all know, consultation can also be provided to the parents. So for example, a BCBA or the school adjustment counselor can consult with the parents to help them like create a plan or give them tips on how to work with the student at home. So learning doesn't just end at the school day. It's also about like how the student is in the community as well.
I wanted to just note one thing on the IEP. There's the section, if anyone has been in an IEP meeting, you might be familiar with the section that says, because of my student's disability, they are more vulnerable to be the victim of bullying or to perpetrate bullying. And students can be for both. But that is very important. I know that like the word bullying feels like you don't obviously want your kid to be labeled as like, oh, they're more likely to engage in bullying, but it actually is important if they do, if there are some there is some conduct that's disability related where the student, has social emotional challenges and so has some, issues relating to peers, some social issues. It's important that that's actually in the IEP because that way that is something that you can point to in a manifestation determination review, where you can say, my student's disability makes them more likely to actually act out against other peers, and have those social issues. So I know it doesn't feel great, obviously, to say that in the IEP meeting, but that is an important note.
Thank you. I just share real quick. I mentioned my oldest daughter has special needs, and I knew as a mom that something was wrong, but I didn't know. I didn't have the knowledge or the education, and it wasn't until she was 24 years old that she was diagnosed with autism. So I had been like asking the school for evaluation after evaluation. I knew something was different, and sometimes you just really have to be persistent um, and that's why it's important again that you attend sessions like this. I can't drill it in you enough. Okay, so with that said, thank you very much. We have two more questions in regards to school discipline.
This is regarding privacy. What action can be taken if administration accidentally sends an incident report with an elementary student's name to the entire parent email distribution?
Talk to a lawyer. That's what I would suggest. That's both a violation of state and federal law. So I think that sounds more specific that you need to talk to a lawyer to see what actions can be taken under that circumstance.
Yeah, so that violates FERPA. And so I'm blinking what FERPA stands for.
Educational Record Production Act.
Something like that.
So,
FERPA.
yeah, FERPA, FERPA. Educational Records, it's a privacy act. And so what parents can do is they can file with the problem resolution system. That's part of the Department of Elementary and Secondary Education. They take care of certain complaints. And usually if there's like procedural violations or privacy violations such as this. And so parents can file a complaint. And what can happen is if PRS decides that the school was in violation of FERPA, then they can basically make them take certain action steps to correct what they did and make sure it doesn't happen again in the future.
Thank you. That was FERPA, FERPA
Yes.
through DESE, right?
Yeah, you could
Okay.
file with DESE.
With DESE. Okay. I'm going to put that in the chat for who asked that. And then this is more related to quick question back to the IEPs. Do parents have to wait until an IEP is up for the annual evaluation for changes to be made, or can they request that at any time?
Anytime.
Even evaluations, if there are new concerns popping up, parents can actually request for reevaluations of the student a lot sooner, and they can actually request that evaluations be moved up as well.
Hi, I'm curious about the records and documentation of interactions between the school resource officer and students. And so I guess my question is, what can parents and children do to protect themselves? So what is required for documentation when there's an interaction with a school resource officer? What can parents and children do to protect themselves if they feel like there's a pattern of interaction from a school resource officer, and whether that's race-based? And then as to disparate discipline that occurs within the school system, what can parents do to protect their kids? I know that's a very loaded question.
First of all, as a defense attorney, my advice would be you don't need to speak to anybody. Keep your mouth shut. If the school wants to speak to you, I would love to speak to you, but I can't do that until my parent is here. If you allow me to call my parent, we can have this matter resolved. Same thing with the school resource officer. You don't have to be disrespectful. Officer, at this point in time, I have nothing to say to you. I will be happy to speak to you once my parents get here. Or my attorney. Usually if there's an officer, I'd say ask for an attorney. That kind of shut things down pretty quick. I think that first addresses the interaction. I don't know if there's any documentation that needs to be done. It's based on the interaction. If it's just a interaction in the hallway, I doubt that there's going to be any documentation. If there's an incident, there might be an incident report or a subsequent police report that would go with that. Similarly with school-based incidents and issues, sometimes what you think is a strictly school-based problem becomes bigger. That's why it's important not to say anything. You don't necessarily need to explain yourself at that moment in time. Sometimes some time allow you to be able to figure out what you need to say. Oftentimes people think, let me explain, and they end up just digging a bigger hole for themselves. So restraint is the best thing I could suggest. And for parents to sort of do the same thing. Oftentimes parents show up, what did you do? Tell them the truth. No, let's hold on. Let's figure out what's happening first. Talk to your child privately, figure out what's going on first. And if you think this is a situation where you need an attorney, you let everybody know, I need an attorney. That shuts the systems down pretty quick, and you speak to somebody before you start making statements. Now, I'm not saying you shouldn't make any statements, but be advised as to what your statements and the consequences of those statements could be before you start making them.
I would also add that so it's going to depend on the memorandum of understanding that the school district or sometimes charter school and the police department have. So there's an agreement between them. And so it depends on what their established policy is, like are there incident reports or like, how the interactions are handled. I would also say that for school discipline matters, school resource officers should not be at discipline hearings unless they are testifying as a witness because they were actually there during a certain situation, but they should only be there for that moment when they're offering testimony. After that, they need to be out because that then is a FERPA violation, but also what you don't want is for the school resource officer then to take that information and file a delinquency complaint against the student.
Also, for school disciplinary hearings, similarly, talk to your student outside of the hearing, and then you represent your student in the hearing. Student, keep their mouth shut. So you could say, I spoke to my son and my son told me X, Y, and Z, while your son is sitting there with his mouth closed. Because of what I've also seen as school disciplinary hearing happen, somebody type up a nice report and hand it over to the school resource officer. Now that becomes an issue because if you made statements, everybody in that room is a witness against you. So for the student, to protect the student's right, that person needs to keep their mouth shut.
Mm-hmm.
You could talk to your parent, you could say, this is what happened, and the parent can recount what they're told, and that's it. You don't need to do anything beyond that. If you're gonna get suspended, you're gonna get suspended anyways. I don't think the story changed based on who's recounting the story. Oftentimes it's parents kind of freak out. They have that freak out moment and they're like, be honest, tell the truth. And then a couple weeks later, they're meeting with me because the child is facing some kind of charge.
And I want to say, like, obviously, like the safety of, staff and students come first. And so the issues that we typically see with SROs, though, are usually situations where the school can handle it. They can have a hearing for the student. They can offer in-school suspensions. They can discipline the student. Like sometimes, we see SROs get involved where there is like a fight, and it's like a typical school fight. No one is seriously injured, but all of a sudden, a student is a felony delinquency complaint has been filed against a student for assault and battery, where it would typically be handled by like a suspension hearing, for example. And so those are the types of situations where we want to make sure that it's handled through the school and not through the courts, because kids make mistakes. and they don't make smart decisions. Like we were all, teenagers once. And so, we've all made mistakes. And, part of, being in school is also like learning how to socialize, learning how to appropriately behave. Not to say that like, it's okay for some of these behaviors, but not all of these behaviors require the courts to get involved.
Also, for the last question about if a student feels like they are being disproportionately punished for their race compared to other peers, unfortunately, there's not. I mean, you can file a complaint with the Office of Civil Rights. I mean, unfortunately, it's kind of hard to prove that as just the one student without like the data to back it up. But if anyone is facing that issue, they can also call our intake line and we can work with them.
If it walks like a duck, quacks like a duck, and looks like a duck,
So
there's a pretty good chance it's a duck. What you find is because of the privacy laws, you can't prove what you know is happening. And there's a reason for that, right? So you can't actually say, here, so you'll hear, and if you're anecdotally with all the minorities in the student bodies sort of recounting similar stories, that's a problem. And I think if you're dealing with that, you need to call it what it is. You need to name it, you need to address it, and see where we go. And I think without having that discussion and without potentially sometimes educating people, you're gonna keep having the same issue. So I think not to push it under the rug, but you need to name it and call it what it is and have discussions about ways to mitigate that. And that way, you're problem solving versus just sitting there and being upset about something.
Thank you. I'm going to keep it moving. In the interest of time, we have 3 more topics to cover: bullying, English learners, and students impacted by homelessness. So I'm going to ask, so that we could get through this, that we hold off our questions until the end, if that's okay, unless you have a really burning question. But please write it down so you don't forget, and hopefully we can answer that for you at the end. So next topic, bullying. And we actually only have 2 questions to this topic. The first one is, what can parents do if their child is being bullied at school?
Report the bullying in writing. That triggers each school in Massachusetts should have a bullying policy, and it's usually part of the handbook. Report the bullying in writing, that then triggers the bullying policy, and you can then start having discussion about what needs to happen at that point in time. And I'm speaking vague, but it all depends on what the bullying is. So, but it at least triggers the policy for you to get some remediation.
Sometimes it's also helpful to specifically say, I am requesting a bullying investigation, because sometimes schools will be like, oh yeah, we were looking into it, and nothing really comes of it. So it's sometimes good to specifically say you want a bullying investigation, and they should then conduct an investigation and send you a report based on that investigation. That report will say, we've interviewed several people, we looked at video footage, whatever. We found that these claims were substantiated or unsubstantiated. If you do get a bullying report and it says that, whatever was reported is unsubstantiated, you can also ask to view the footage, and ask to see the redacted versions of interview notes. So sometimes, I mean, schools will generally not send you the video, but you can often schedule a time to come in and view the video at the school, and view redacted interview reports. Again, if other students were interviewed, you're not going to necessarily be able to like see their names, but you should be able to ask the school to view redacted copies, that like have all personal information cut out of them.
Yeah, and so what Dean and Sophia just talked about, that also applies for students who are being bullied in social media, because we know that bullying doesn't end like at the end of the school day, unfortunately, anymore. It could be things that are nonverbal. Like the definition of bullying is pretty expansive. And so it just has to be repeated acts of like, intimidating or harassing another student. also, if a student is being bullied by another student in another school district, parents can still request a bullying investigation, and the two school districts should work together in order to resolve the issue.
Thank you. Next question is, what can parents do if their child has been sexually harassed or assaulted at school?
So they can request a Title IX investigation. And so Title IX is for situation where a student is being bullied due to their sexual orientation or because of their gender. If they have been sexually assaulted or harassed, the school needs to conduct an investigation. This is actually federal law. And so they need to do formal interviews. And they need to make sure that while they're doing the investigation, the student also is protected and feels protected as well.
The parent can also go to the juvenile court, and if it's a sexual assault, they can file an harassment prevention order. All it takes is one incident. If it's regular bullying or assaultive behavior, they need 3 separate and distinct incidents to put in the affidavit. That triggers the harassment prevention mechanism, which point there'd be a hearing. That other person would be summoned into court. They may be provided counsel, but a judge can then actually put a stay away. It's kind of like a restraining order in place that then can be enforced if necessary. Additionally, if somebody's being sexually assaulted in school, I think you should, that's a situation we might want to talk to the school resource officer. That way, that issue can be addressed in the manner in which it should be addressed.
Also, if a student is feeling unsafe for any reason at school, you can always request that the school create a safety plan. And that should include, if there's a particular issue with another student, it might include, making sure that those students aren't in the same classes, that they have different walking routes or whatever, various things or that they have access to, see their counselor, various things. You can request that the school come up with a safety plan and kind of work with them to create that.
The school also has to be aware if there's any type of retaliation by that particular student, by their friends, peers, even by staff. They need to make sure that no retaliation is happening, and if so, there are some disciplinary actions that can be taken against the person who is retaliating.
What about bullying when it happens on the bus? And a lot of buses now have video recordings. What about access for parents to get those recordings?
The school, I mean, that would still count as a school issue if it's on the school bus. So the parent should be able to still ask to, view the footage. Again, there can be issues with that just because of the privacy of the other students involved. And so other students are likely going to be on the video. So the school might need to alter the video to protect the privacy of other students. But there should be, this parent should be able to ask to still view maybe a blurred video or something like that. But they should be able to request a bullying investigation same way. And another kind of, I guess, easier solution is also just to request a bus monitor. And that can sometimes alleviate some of the issues because then there's another person, but you should be able to still request a bullying investigation. There could be a bus safety plan where, you have assigned seats on the bus or something.
Thank you. Okay, moving on to the topic of English learners. As we know, the Cape has been becoming more and more diverse, and so it's really important that we meet the needs of our community members and, in this case, our students. How are EL students identified? And I don't know if that's really a school question or, yeah.
Yeah, so when a student is first enrolled into a school district, the school district has to give the parents what's called a home language survey, and that survey should ask whether the student speaks another language at home, or if the parents speak another language at home. And the home language survey can actually be provided to the parents in their language as well.
Thank you. What types of educational programming is available for English learning students in Massachusetts?
So there are a number of different types of educational programming for English learners. The most common one is the Sheltered English Immersion Program. So basically, it's a program where very little of the students' native language is used. It should really be all English, and they can use different ways of trying to get the student to learn the English language. So they might use pictures or text, for example, but very minimum of the student's native language should be used. And usually a number of students who speak different languages can be in the same classroom when it comes to sheltered English immersion. There's also transitional bilingual immersion. So that's, we don't see that too often, but basically they use the student's native language in order to help them learn English. But the idea is for the student to eventually like learn and be instructed less and less using their native language. There's also the dual language immersion, and that is where, and this is what I would prefer, is it's a school where, for example, they have native Spanish speakers and native English speakers in the same building. And so they're learning from each other, and classes are taught in Spanish as well as in English. So by the time that the students leave that program, what is the ideal is that students are both fluent in English and Spanish. There is also the life program. So that's for students with interrupted education. So for example, it's usually for students who are coming from a different country where they may not have the the opportunity to receive an education, or their education for some reason, such as like turmoil, warfare, their education was interrupted for at least, I believe, 2 years. And so there are certain special programming for those students. And so the program can look different depending on, at what level the student is learning English, as well as like them also basically catching up in their education as well.
Thank you. Can students be identified as both EL students and special education students?
Yes.
Yes. And actually, if a student is an EL student, it speaks another, has another language that they speak, they should be provided evaluations in that they should be provided bilingual evaluations. So, if you have a kid at home who is an EL student, and the school is proposing evaluations, you should ask for the evaluations to be done by a bilingual evaluator. And especially if it is like a, speech and language evaluation, that's super helpful to have be bilingual, and it should be an evaluator who can then speak their home language as well as English and test them that way.
So there are some languages where there are not going to be any evaluations like in that language. So for example, Haitian Creole, Cape Verdean Creole, Quiche. And so as long as they have an interpreter there to help with the evaluation process, that should be fine. What I would also say is that, in no situation should like a parent be interpreting. We've seen that before, unfortunately, and it should be someone who's certified in interpreting.
Thank you. Last topic for the evening, students impacted by homelessness. What is the McKinney-Vento Act, and who is considered homeless under it?
A little McKinney-Vento is a federal act, and the gist of it is that it provides protections for students impacted by homelessness. So the kind of big takeaways are that if a student becomes homeless, they are entitled to stay, and they become homeless, and then let's say that they are their school is in Brockton, but they have moved to a shelter in Fall River, that student has the right to remain in Brockton, and so that their education is not interrupted. They also have the right to enroll in Fall River, if that is what they choose. They also have the right to have transportation provided to them. So again, if they are in a Fall River shelter, but their school is in Brockton, they should be provided transportation to and from school. That generally is like, it's what's considered reasonable. It's generally up to an hour. So like, if a student is going to school in Barnstable and they end up in a shelter in Springfield, there's not going to really be transportation. Probably the student needs um, to transfer. But who qualifies is actually it's a pretty wide array. So it's any student that is in, a homeless shelter, who is, anything that you might think of as homeless, but also students who have any sort of substandard housing. So if a student is in any sort of situation that is, any sort of building or whatever that's not meant for human habitation, they qualify under McKinney-Vento. If
Sleeping
kids
in their
are,
car?
yeah, in their car, McKinney-Vento. And even if they are living with family, if that's not meant to be a permanent situation, they still qualify. So like, if uh, parents and their kid are having housing insecurity and they're crashing at a grandparent's house, and that's not meant to be like their like permanent living situation, that qualifies. If students have substandard housing for what they require, so let's say it's like a 5-children family and they're living in a 1-bedroom apartment, kids are sleeping on the couches, on the floor, that child still can qualify for McKinney-Vento. So it's not just like in a shelter or outside, or it really does encompass a lot of different things. If you're, for example, seeking refuge at night in a building that is not supposed to be a house, not supposed to be for habitation, like you're spending the night at a library or a school or wherever, that that all qualifies under McKinney-Vento.
Yeah, and I would just add that students are protected under McKinney-Vento until they find permanent housing. But even if they find permanent housing, say in the middle of the school year, they continue to have that right until the end of the school year.
Thank you. Anything else before I move on? This is a real issue. I mean, we all know about the housing crisis on Cape Cod. So many of us know of families sleeping in cars, sleeping at campgrounds. It's real and it's heavy and it's a lot. So what rights do students experiencing homelessness have in schools? And you touched a little bit on that.
They have a right to anything that is offered to their peers who are permanently housed. So extracurricular activities, after school activities, the same type of educational programmings. If there's a free lunch program, like say they move to a new district where there's a free lunch program, they get the free lunch. Child's care, so like anything that the district would offer to the house students, that's exactly what the student should be getting. They even have the rights to have their credits transferred. So say they're a high school student and the school credits do not align, like the school districts don't have the same graduation requirements. So they could have those credits transferred. They could also get partial credits, anything in order to make sure that there's a continuation in the student's education that is not going to prevent them from, not graduating on time, for example, or not being promoted to the next grade. If they are on an IEP, and this IEPs, are covered under federal law. So it doesn't matter where the student moves, in the US, they're still protected in terms of like having their IEP services, their 504 services, for example, as well.
Also, the students have the right to, oh my God, I completely blanked on what I was going to say. What was it? Ugh.
They can enroll without documentation.
Oh, yes, yes, you reminded me.
Pull
It's
a
that
Tara.
students have the right to enroll in school even if they don't have all their records yet. So I know that, like Massachusetts law requires certain immunization records to enroll. If it is a student that is protected under McKinney-Vento, and again, let's say they are living in one in location A, but they are attending school in location B. Let's say that now they're transferring to the school where they currently reside, and they have the right to enroll and start attending school even while the records are still making their way over.
Thank you. Last question of the evening before we move on to open questions from the audience. What happens if the school district does not believe the McKinney-Vento Act applies to the student?
So if there's a dispute about it, the student has the right to whatever they would have the right to under McKinney-Vento until the dispute is resolved. So for practical purposes, they are treated as though they qualify under McKinney-Vento until it has been resolved otherwise. So again, let's say a student is, in going to school in Fall River. They now are living in a shelter in New Bedford. They have the right to, if the school doesn't believe, that they qualify under McKinney-Vento, for the time being, the student is allowed to continue going to their school in Barnstable. So they are allowed to, remain at that school if that's what they choose, while they're kind of figuring out whether the student actually qualifies.
Seems like such a broad qualification. I can't imagine that being the case, but not surprised. Any other input?
Yeah, so there is a homeless liaison that works at each school district, and then there are regional ones as well. So if a school district does not believe that a family qualifies or students qualify under McKinney-Vento, and I just want to clarify that McKinney-Vento applies to the students. So regardless of how they're viewing the parent situation, so long as the student is considered to be impacted by homelessness, they qualify. For a situation where a school district disagrees, they should be connected with the school liaison, and they should be helping them, file with PRS, the problem resolution system that is a part of DESE, in order to, resolve this dispute between the school district and the family.
And oftentimes the places I've seen the sticking point with McKinney-Vento is around transportation, because that's where real money come into play. So that's where you might find a lot of pushback from the school, especially if they think that they're spending out a lot of money. So, that's where you look for some sort of resolve.
Thank you. Okay, so that concludes our questions for the evening. Are there any more questions from the audience?
If a child is undocumented, can they attend a school without having any records? And if so, can they still get tested for an IEP or 504?
So is this a situation where the student is experiencing homelessness? Is that
I think it's just relating to an
undocumented?
undocumented.
Okay, yeah. So if they're undocumented, so all students in Massachusetts have a right to an education. So yes, they can still be enrolled. And there are actually some programs that help with like getting certain records like immunization. There are even like mobile services now. I know they offer in Brockton, and I believe they offer it, because of a lot of folks who, a lot of new arrivals who are undocumented coming into Massachusetts. There are now like some mobile like hospital services, so students can get, vaccines as well as like physical examinations. It's really amazing that they are offering this now, and they actually so they'll come into like certain communities where there are more families who are undocumented, and they'll make sure to like come back. Like say for example, you need your second shot like 2 weeks later, they'll come back, they'll schedule it with the family, and they'll come back and provide that the vaccines for the family. But basically in Massachusetts, like they will figure out any way possible to make sure that a student is enrolled immediately. And like the in terms of like any services regarding like services for English learners or IEP 504 services, they should be evaluated just as any other student.
And then if that added layer of homelessness was there, they would also be protected by
Yes.
those other.
And there was a question not too long ago when unfortunately there were a lot of folks who were undocumented who were brought to Martha's Vineyard like unknowingly. There was a question about whether or not they would qualify as being homeless since they did not originally live in Massachusetts and then become displaced. They came from another country, and they would still be treated as if they were experiencing homelessness. And so luckily, the Department of Elementary and Secondary Education provided some guidance around that.
Thank you.
Hello. I wanted to ask about bullying, and is there any obligation or timing on how quickly the administration has to respond to allegations of bullying or a request for investigation? And I'm just thinking of situations where like bullying on a bus, let's say that happens like daily, right? Every day that they're on the bus together. If you make the request, it could take 2 weeks. It could take, and I'm just curious if you know about that.
I think that you would have to look at the district specific anti-bullying policy. I don't think there really is a timeline, but if it is like a situation where it's like, okay, if I send them to school tomorrow, they're going to be bullied. This is an urgent situation. Even without a bullying investigation, the school should be able to propose a safety plan, even if they haven't done any sort of investigation. If you say, these are my concerns, the school should be able to still create some sort of safety plan, even without that. But yeah.
Yeah, I think as soon as it's been reported, they need to conduct the investigation as soon as reasonably possible. Also, there are like ways to address the bullying, such as like through the IEP process. So parents can have a team meeting to say that their child, like possibly due to their disability, is vulnerable to the bullying. And so that's another way to get a response from the school district a lot quicker.
Okay, thank you.
Hi, I had a question for if a parent, guardian, or a grandparent raising grandchildren, if they suspect that a child is being discriminated against or not necessarily, well, I guess it would be considered bullying, but discriminated racially, what investigation, which agency is responsible to investigate the discrimination, or is it the parents' proactiveness to lodge a complaint with the school, or would they go through agencies such as Massachusetts Commission Against Discrimination to investigate that? How do they address that?
Is the bullying being done by the student population or by adults?
If the parent suspects that the child is being discriminated
By
against
other students?
by other students or even the school itself.
I think if it's by other students, I think that would fall squarely within the bullying policies of most schools. So you would I always suggest doing it in writing. You'd make a complaint in writing, documenting what your concerns are and asking for an investigation. At that point, the school would look into it to see if it's substantiated. The issue that you might run into is some people don't know how to identify race-based discrimination, right? unless you're saying the N word and you have swastikas and stuff, they don't know how to analyze the subtleties and the things that. So sometimes it might be important for you to communicate why that is not okay. So I think part of it is communicating to the school and the investigators the things that they should be looking for that would identify something as being discriminatory, because something done to a white student and something done to a black student might not carry the same weight, and they need to sort of understand that, because sometimes you realize these kind of investigations aren't going to be done by a person who's a minority. It's going to be done by somebody else, and they might not have the context to apply to the situation. So you need to sort of, as best as possible, communicate why something is an issue so that they can look for it appropriately.
So the bullying law actually covers staff as well. So if staff is bullying students, the school needs to do an investigation. But like Dean said, it's really hard to prove racism. Like it needs to be clear, like I'm doing this because you're a person of color. Unless you can get like a number of students who are experiencing the same thing. And like there is like little room to argue that it was because of anything else other than race. But the Office of Civil Rights is the venue where you can file a complaint against the school district for discrimination if the school district did not respond appropriately to the complaint, the initial complaint.
I will also say look at school districts' student handbooks because, for example, Duxbury does have a DEI coordinator who is supposed to be notified anytime there's any sort of complaint about racism. So look at the student handbooks for districts because they might have specific district policies about how they handle specifically allegations of racism. So something else.
I have to say, I'm not surprised to hear that racism is hard to prove in the school district because as we all know, these systems were not built for us, right? So that's unfortunate, but that's not surprising to hear. I just want to point out that Leslie is here from Leslie Dominguez Santos. Did I say that right? With my horrible Spanish accent, my grandmother's turning over in her grave. Is here from the Barnstable County Human Rights Commission. Did I say that right? And that's also a place, a resource to apply for to record discrimination and document discrimination, and they can help you with that as well. So, and Marley,
Sorry,
I believe you have.
I wanted to note really quickly also for bullying specifically, it is good if students can report to staff because unfortunately a lot of times we have them reporting to parents and parents they're going to believe them the same amount that they're going to believe the kid. So unfortunately, a lot of times it is helpful if the student can tell staff members what has happened so that they can corroborate it.
Well, this is a question related English learners. From your experience working with the district, with the school district and also with families, do you feel like that the capacity of translators or interpretation that works in the public school is enough to, provide the resources and information that families need, not only for the child on a daily basis, also, family resources in general? And the second question is, from your experience as well working with families, could you just mention the most common, issues or conflict that families face due to their barrier language?
The most common that I've come across is school districts not sending information home in the language of the home. Whether it's a letter for suspension or an invitation for something, they send it home in English. So therefore, sometimes they don't even know that this is a Spanish speaking home, right? So you run into that a lot in terms of them being sensitive enough to say we need to do this in multiple languages. Additionally, I also find that when you have meeting where they need to provide interpretation, they don't have certified interpreters. What you have is a teacher or a staff member who may know the language sitting in the room interpreting, which is a totally different situation than a certified interpreter. So I think these two things shows, one, a lack of sensitivity, and a lack of the application of resources to solve a specific problem, which is pretty simple and easy to solve. And by doing that, you don't necessarily get the appropriate buy-in from the family that you're working with because they don't see you making the effort. And oftentimes because they don't have the appropriate language person, they don't get you're not communicating with them effectively, so that you don't get the buy-in that you need. So I think that that's a place where a lot more work could be done.
So, the education unit is actually part of a statewide coalition that is working on a bill to actually address interpreters and translators in school to make sure that they have a certain amount of training, and that certain staff in school districts are actually given the title, specific staff are given the title of interpreters or translators. And so right now, so we did testify last summer on it. Don't believe that there has been much movement on that, but it's something that we are continually working on with other legal aid organizations. There has also been some guidance recently passed by the Department of Elementary and Secondary Education to give schools like more direction in terms of like providing more resources in terms of like language services for families. So that was, a big step that, we were grateful for. And I would say, for families that speak another language, I would think that one of the issues that we see is that there aren't interpreters at IEPT meetings or hearings, which is really problematic. Like if you don't have an interpreter there, or you have like a family member interpreting, or you have like a provider interpreting, there are certain like terms in the special education world that is really hard to interpret, correctly. And so you want to make sure that you have someone who is actually trained and skilled in being ordered to convey that message to the family appropriately. And then if you're in a hearing and you don't know what's going on, then they're violating your due process or your child's due process rights, because you have a right to participate in that hearing as well.
Doing their best, but this is a large, range of service or, activities or programs that are available in the community that sometimes probably are not accessible because of the lack of, interpreters.
When it comes to interpreters, it's not that big a leap. There's actually language lines that you can literally call up and they would provide an interpreter on the phone with you. So it's not as if you need to ship in an interpreter from Boston to come down here and interpret a specific language. It might be an issue if there's a specific dialect of like Khmer or something that you need that might not be properly available. Then you can make the necessary arrangements ahead of time to get that done. And it could be done online, could have somebody log in on a Zoom, you could have somebody on a phone call. It's not that big a deal. This is 2024. This stuff it's a click away. I've met with clients in my office where I call up the language line and I say, hey, tell them this, and they're sitting there. I put the phone on speaker and we're talking. It's about having the respect to take that extra step, and I think that's part of the conversation. Is if I respect you enough to make sure that you understand what I'm saying, I am going to do the things that I need to do to make that happen, especially when the things I need to do is not that difficult.
That actually
That's the point.
That actually reminds me, part of the funding that was provided as a response to the pandemic was actually given to school districts in order to address language capacity. And so like what Dean was just saying about language lines, like they were given the money to provide those services. Now, I know that that funding will be ending soon, and I'm not sure exactly how it works for schools, if they have to pay it back, if they don't use it all, but I mean, the funding was there.
Thank you. Any more questions?
Yeah. Maybe you guys can't say this publicly. I'm wondering, though, if you have education attorneys that you work with for families who are above your 200%.
So there are some exceptions. So so sometimes we have grandparents raising their grandchildren, and so we provide services if families are like a little bit above 200% if the parents are considered elderly, and that is because of specific funding that we get. And if the student is a victim of a crime and it somehow relates to their educational issues, we do have a CLAVIC unit, so victim of crime unit, and so they also don't adhere to the same 200% guideline. There's also the health law advocates, and they go a bit over us as well. They go a bit over the 200% income guideline that we have. And then we do have the private attorney involvement coordinator. And so if we aren't able to take a case, we can hand it over to the PAI coordinator to see if there is an education attorney that will take a case pro bono. If we cannot provide the service to the family, we are happy to refer them out.
Ashley, Sophia, and Dean, thank you so much for sharing your expertise and your knowledge with us this evening. Yep. Oh, one more.
I just wanted to know those things that were provided during the pandemic, things like social emotional supports, the language line, ABAs for children who need those things. How can you make a compelling argument when those funds end to keep some of those services in place? If they work, they work. Do you understand what I'm saying?
Yeah, so that's actually up to the federal government. So not exactly sure, at least on the federal level, but in terms of like state level, like speak to your legislators. And I guess the same thing, for the, federal government as well, like speak to your representatives.
Call your congressman. The need was there before the funds were provided. The needs didn't disappear now that we all kind of seem to have forgotten about COVID. So call your congressman, let him know what your priorities are, ask for him to pass legislation to actually fund these priorities, and then that's what we need to do.
Thank you very much. Thank you all for coming. I'd like to just thank the Barnstable County Bar Association. I'd like to thank the Justice Center, and I'd like to thank Sonia Fellman for organizing this. So thank you all, and we hope this was helpful and beneficial, and please go back and share this knowledge with your community. All right, have a great evening.